Well, recent court opinions have determined two different grant and loan programs created by the American Rescue Plan are unconstitutional for being racially discriminatory. Well, Roger McEowen with the Washburn University School of Law joins us now for an update on the situation. Roger, as always, thanks for your time here today. Now, one of the programs is the Restaurant Revitalization Fund, which is administered by the Small Business Administration. Can you give us a recap of the issue on the court ruling on it?
Yeah, good to be with you, Janet. That fund created by ARPA is not unlimited, and that's a key point to the case I'm going to mention here in just a moment. The SBA distributes the money from the fund on a first-come, first-served basis with a catch. And the catch is that fund distributions during the first 21 days were restricted to applicants that were at least 51% owned and controlled by women, veterans, or, and this is the key, the socially and economically disadvantaged. And if you didn't fall in that category, you could apply during that initial 21-day period, but you wouldn't get your grant until the initial period expires. But if the fund had already been depleted, you got nothing. And that's what gave us a case. You had a restaurant owned, husband was white, his wife was Hispanic, nobody was over 51% ownership, so there wasn't 51% ownership. They didn't meet the definition. Court said you can't discriminate based on race, and so they put the program on hold while it winds through the courts.
Now, USDA loan forgiveness, it's also recently come under fire for discrimination as well. What are the highlights from that case?
That's right. Same problem with that program. There was another section of ARPA that directed the Ag Secretary to pay up to 120% of the outstanding debt in existence as of the beginning of this year of a socially disadvantaged farmer or rancher. Well, there were a number of white farmers that sued and said, look, you can't do that. That's constitutionally defective. It's discriminatory. And the federal court in Wisconsin on June 10 said that's correct. And the court entered a universal temporary restraining order that barred the USDA from forgiving any of those loans until the court rules on all the motions and it gets through the court process. So we've got two of these programs under ARPA that are on hold until the court process works its way out.
So, Roger, what is the big takeaway and what kind of timeline are we looking at?
Well, second point first, the timeline is going to be a while. This is going to take a while for this to work through the courts, and there are multiple other cases, particularly on the USDA loan forgiveness program. I know of at least 5 that are out there. I think 2 are in. They both have said it's unconstitutional. There are 3 that are still out there. I think we're going to have to go all the way through the process, and it'll probably end up in the lap of the U.S. Supreme Court, but that's not until this fall at the earliest. The court will go on recess now, but probably into next year, and these programs are going to sit there on hold unless the government retools them. And the big takeaway, you can't do these things. This is 2021, and you've got to provide these programs for everyone that is eligible, and you can't discriminate based on race.
All right. Well, Roger, as always, thank you very much for your insight today. Roger McEowen, he's with the Washburn University School of Law on the phone with us today. You can learn more online at washburnlaw.edu.